president, power and functions, that is, and that then is your emergency power, different powers means we have to discuss the power of the president, that is legislative, executive and judicial power, and financial, and then we come to the emergency provision, then thereafter the prime ministers and council of ministers and the cabinet, and collective responsibility of the council of ministers. And next point of discussion is cabinet and parliament, sources of prime minister's power and functions, its influence upon the cabinet, and last we shall discuss about the president and the prime ministers, and at last we have to conclude this chapter, that is we have to come across all these points, 7 points, as I have categorized. So introductions, let us discuss about the introductions part of the chapter. So president is the, as you know, he is the nominal or the formal head of the state. The executive power vested in the hands of the president, and he is the ceremonial head of the state. He is the ceremonial head of the state, and prime minister on the other hand is the real head of the state, or he is the head of the government. So presidents perform all his functions with the aid and advice of the prime ministers. So before going to discuss this president, I have to that is say one thing, that president is the all the executive powers of the president, that means vested in his hands, and that is the reason why he is the executive head of the state. No doubt he is the that is your nominal head of the state, but still then all the executive powers are exercised in his name. Whatever the prime minister is exercising his power, he is exercising the power in the name of the president. So this is the position of the president in case of India. And the president of India, let us discuss about the second point, that is president of India. Article 52 of the Indian Constitution says that there shall be a president of India. It was stated that Article 52 of the Indian Constitution states that there shall be a president of India, and who is the ceremonial or the constitutional head of the state. No doubt he is, as I have already told you, because in India we have a parliamentary setup of government. So that is the reason why, and we adopted the prime ministerial form of government. So the executive powers, no doubt, vested in the hands of the president, but it is the prime minister who is the real head of the state, who exercise all the executive power in the name of the president. बुझीगला? I mean to say that जे जहाँ सब क्षमता अच्छी से क्षमता गुड़िक राष्ट्रपति नाम प्रधानमंत्री उपभोग करती. बुझीगला? Who is the, and president is the ceremonial head, not he is not the real head of the state. He function, all his or his power were exercised only with the aid and advice given by the prime ministers. So no doubt he is the ceremonial head of the state or constitutional head of the state, and he or the office of the president is elected, indirectly elected for a term of 5 years. That means the president is elected for a period of 5 years, and he may be removed from his office by the process of impeachment. And the constitution also provides for the post of a vice president. That means the post of vice president is there, and he also indirectly elected, and he served the state if president resigns or removed by impeachment or there is death of the presidents. So in this way, presidents of India under Article 52 of the Constitution of India, there shall be a president of India, and the president is that is elected by the indirectly elected by the members of the that is your parliament in the process of that is your proportional representation by means of single transferable vote system. So let us discuss about the next point, that is your what is the qualifications for the post of the president. The second point of our discussion is what is the qualifications. Article 58 laid down some of the qualification for the office of the President of India. Article 58 of the Constitution of India laid down some of the qualifications for the office of the President of India. And the first and the foremost qualification is that he must be a citizen of India. The first important qualification is that he must be a citizen of India. Then second important qualification is that he must have completed the age of 35. And third important qualification is that he should qualify for the election as a member of the Lok Sabha, that is lower house of the parliament. And fourth one is he must not hold any office of profit at the time of election, either under the state government or government of India or local authority. He nor be a member of either house of the parliament. That means while contesting the election for the office of the president, he is not associated with any office of the state government or central government, and he also or local government, as well as he nor be a member of either house of the parliament. That means he also should not be a member of the Lok Sabha or Rajya Sabha, but he was elected by the that is your members of the parliament by the process of proportional, that is your proportional representations by means of single transferable vote system. So now the question is that now the process of the elections. So what is the process of the elections? The method of election, the Constitution of India provide an indirect election process through which through electoral college, through which or through electoral college, which is composed of the elected members of the parliament and elected members of the state legislative assembly, elected members of the parliament and the elected members of the state legislative assembly were take or participated in the electoral process of the that is your president on the basis of proportional representations. I have already stated you that the proportional representation, that means it is one proportional representations by means of the single transferable vote system. This is the process through which the office of the president or the president is elected. So proportional representation by means of single transferable vote system. Now the question arises that you are say for an example, while giving your that is your election, participating in election process of a MLA or an MP, then it is your election process is known as the universal adult franchise. बुझी होची ना नहीं सबीरानी?
Yes, sir.
That is in general election it is that is your universal adult franchise. Then but in case of the presidential elections it is proportional representations by means of the single transferable vote system. That means choice based system, preferential vote system rather you may see. So here what happened, this is done through a formula, that is the formula that means the MLA, the vote of an MLA is count on the basis of the total population of the state divided by total number of MLAs of that state divided by 1000 is equal to vote of an MLA. बुझीगला total population of that state divided by total number of MLAs of that state divided by 1000 is equal to the vote given by an MLA of that particular state. यदि ओडिशा को निया जाए, say for an example, so the vote of an MLA is count on the basis of total number of population of the state. What is the population of the Odisha? That is, say for an example, 4 crore. Then total number of MLAs, elected MLAs, that is 147 divided by 1000 is equal to single vote given by the, that is your MLA. That is the vote count on this basis, and in this way the MP vote also counted. That is also included in a formula, that is total vote cast by all the MLA, that is total vote cast by all the MLAs divided by total number of elected MPs. Total vote cast by the all the MLAs of that state divided by total number of elected MPs of that state. So that constitute is the that is your that includes the vote of an MP. So in this way, what happened? The vote were counted, and the proportional representations by means of single transferable vote system, that is the elections to the president is made in this process, and that is they provide their elections. This is not a that is your physical class, otherwise I will give you the example in the blackboard how the proportional representations is given, or how the presidential elections took place. A, B, C, D, if the candidate were 4 candidates, then they will cast their vote on the basis of preference, that A will given first preference or B will given first preference, then C will given third preference. In this way, the vote will be provided or given to the candidates, and by means of this single transferable vote, elimination system start, and ultimately one will be declared as the elected. So in this way, the process of the election will going on, and the presidential election will take place, and president will be elected. That is, the process is known as the proportional representations by means of single transferable vote system. Then the term of the office and the removal of the presidents. What is the tenure of the president? The president is generally elected for a period of 5 years. He is elected for a period of 5 years from and the day will start from the oath taking day by the, and the oath ceremony will be undertaken by the Chief Justice of the India. So by means of the, that is your the tenure is the normally it is 5 years, and it was started from the day of the oath, and it was done by the Chief Justice of India. And if he resigns, he send the letter to the Vice President. If office is vacant, the Vice President assume the office, and within 6 months, election to the presidents must be conducted. 6 मास मध्य कौन है? Say for an example, if president resigns or the office is vacant, then what happened? The vice presidents assume the office of the presidents, and within a period of 6 months, the presidential elections will be took place, and again it will be restored. So under Article 56 and 61 deals with the procedure of impeachment. As I have already told you, term of the office and the removal of the president. Removal of the how the president can be removed, or how the president can be impeached. So Article 56 and 61 deals with the procedure of impeachment. Impeachment on the ground, first, that is violation of the constitutions. violation of the constitution, and the process of impeachment may be initiated in the either house of the parliament. At, at the initiation of 1/4 of the total membership, who must give 14 days notice, and 2/3 of the majority of total membership of house approves the charge. What happened while that is the process of impeachment is going on? That means the initiation in either house of the parliament. It can be initiated in either house of the parliament, whether that may be the lower house or that may be the upper house. In any house, that means in lower house or upper house, the initiation of process of the impeachment could be started. But the initiation of 1/4 of total membership, who must give 14 days notice, 14 दिन पर्यंत तांको नोटिस दिया जाइथिबो, and 2/3 of the majority of the total membership of house approves the charges. That means 2/3 of the majority of the members approve the charges which are laid down against the particular president. If the majority of the majority and if the president stands impeached and this process is continued in other house and other house approve the same way, then this president will be impeached. बुझी होची ना नहीं? गोटे हाउस रे कोन हबो सेटा 1/4 of the total membership, they will give 14 days notice to the president. 14 दिन पर्यंत तांको नोटिस देबे, and that that initiation will be that is your approved by the 2/3 of the majority of the members, total members of that house, and the house will approve the charge. They will approve 2/3 of the member present and voting, and they will approve the charges against the particular president. And if the same process, that means in other house also 2/3 of the members they will approve the charges, then the president will be impeached. And this process of impeachment is quite difficult enough, because this is one of the provision of the Constitution of India, that is the amending procedure of the constitutions. Rather, sometimes this is one of the basic, that is your feature of the Constitution of India, that is federal feature of the Constitution of India, that is flexibility and rigidity. That means some portion of the Constitution of India, they are to be amended in a very flexible manner, or some portion of the Constitution of India that are to be amended in a very rigid way. And this process of initiation of impeachment, that comes under the very rigid process, and till date no president of India has been impeached. Bujiela? Till today there is no president of India has been impeached. Now we shall come to the discussions, that is power and function of the president of India. So under Article 53 deals with the executive power of the president. The president of India enjoys certain executive powers, and under Article 53 it provides that it deals with the executive power of the president. And what is the power of the executive power of the president? Broadly speaking, the executive power of the president divided into two categories. One is ordinary power and another is emergency power. So the ordinary power may be divided in terms of executive, legislative, and your financial and judicial power. The ordinary power of the president deals with the executive, legislative, and financial power, financial and judicial power. And the emergency power is that is your deals with the emergency provision. That is one of the special power of the president. So what is executive power? Article 75 of the Constitutions provides that the Prime Minister has to communicate to the presidents regarding the all decisions of the Union Council of Ministers. That means the executive power of the president deals with, or it confers under Article 53. What I want to say you that under Article 53, it confers all executive powers of the union and vested the president and empowers him to exercise these powers directly him or through officers subordinate to him. This is one of the important point. That means the president may exercise this executive power directly or through officers subordinate to him. That means it is the prime minister. That means under Article 75 of the Constitution, the prime minister has to communicate to the president regarding all decisions of Union Council of Ministers. And on the basis of that, that means the executive powers of the union government shall be exercised in the name of the president. Prime Minister will be exercise all the executive powers of the president in the name of the president, and this includes that is your executive power of the president. And president is the, now we shall discuss about the president is the supreme commander of the armed forces. He is the, under the executive power, he is the supreme commander of the armed forces, and he also appoints the chief of all the armed forces, that is Navy, Air Force, and your army. So all appointments in the armed forces are made under the authority of the president or under the name, in the name of the president, and president appoint the prime ministers and the other, and by the advice of the prime minister, he also appoints the council of ministers. This is the executive power. That means power to appoint the different official and exercise different power. That is called the executive power of the president. He also, or the president also appoints the chairman of the UPSC. He also appoints the attorney general of the India, and he also appoints the different governors of the states as well as ambassadors, members of election commission and finance commission. These are some of the executive powers that exercised by the president of India. So he is the that is supreme commander of the armed force, and the that is your all the powers of the that is your president exercised by the prime minister. Prime minister is the, as he is the real head of the state, he exercises all the power in the name of the president, and the president of India is also the, that is your chief of the defense forces. He appoints chiefs of army, as I have already told you. He appoints chiefs of navy. He has the power to declare war, conclude treaty, or conclude peace. That means different, that is your treaty were concluded by the government of India, which are to be done by the prime ministers, but in the name of the president. All these powers have to be exercised by him, subject to the ratification of the parliament. That means parliament have to approve all the executive powers exercised by the presidents. And then there is the presidents also promulgates in the legislative power. Say for an example, the legislative power. Next important thing is legislative power. When the parliament is not in the sessions, when the parliament is not in the session, the president promulgates ordinance. That means in the public interest, and ordinance have the same force as with effect as law passed by the parliament. However, the ordinance has the same effect as the law made by the parliament, just like the law made by the parliament, but the ordinance have to be placed before the parliament within a period of 6 weeks from the day of reassembling of the parliament, reassembling of the parliament. Without parliament approvals, ordinance become invalid. That means যেতেবেলে reassembly ହେବ within 6 weeks, the ordinance has to be approved by the parliament, so that that will continue becomes an act, or otherwise it cannot be valid one. And under article 254, that is your president also have the power to remove inconsistencies between the laws made by the central government and the state government. If there is, because as you know, the government of India, or in the, there is the division of power in the center and state, or the while you that is reads about the interstate relations, the division of power between the center and state, or regarding the union list, the state list, and the concurrent list. In the concurrent list, if the state laws and the union laws were made contradictory, then it is the president who, under Article 254, empowers to remove the inconsistencies exist between the law passed by the parliament and the law passed by the state legislature, and subject that is included in the concurrent list. So what happened? There is any, if there is any difficulty, or if there is any deadlock going on between the law made by the state legislature as well as made by the parliament, then it is the president who make, that is your or removes the deadlock in between the that is your law made by the state government and laws made by the central government. This is the legislative power of the, that is your president. Then is your, that is your judicial power. What is the judicial power? He appoints the judges of the Supreme Court and High Court. The power to grant, he has the power also to grant pardon, or reprieve, or suspension, or remission, or commutation of punishment, or that is your sentence of the court, death sentence of the court is to be pardoned by the president. It is the judicial power of the president. This power granted pardon given by the president to removing the extreme rigidity of the criminal law, and that is protecting the person on the humanitarian considerations. I mean to say that president has the power to, if somebody, say for an example, তুমি দেখিদিব যে নাই, they will the that is your serious criminals, they will apply for the pardon of the president. They will apply for the ରାଷ୍ଟ୍ରପତି ପାଖରେ ସେମାନେ କ୍ଷମା ପ୍ରାର୍ଥନା କରିକି, they will apply for the କ୍ଷମା ପ୍ରାର୍ଥନା, or that is your pardon. So this process, or the president has the power to pardon on the basis of the ground of the humanity. So, but what would happen in this regard? The Supreme Court of India guides the president, and on the basis of the advice of the Chief Justice of the Supreme Court of India, he will perform his functions. Next, we shall come to the emergency provision of the Constitution, that is your President of India. And under article, that is your 356, sorry, 352, 356 and 360, the President of India enjoy certain emergency power. That is under article 352 of the Constitution of India, that is the President enjoy, that is or declares, that is national emergency. And under article 356, the President of India, he declares the state of a state emergency. And under article 360 of the Constitution of India, the President of India declares the financial emergency of a country. So let us discuss what is the national emergency first. So first, that is national emergency, that means under article 352, under article 352, it says that if the president is satisfied that a situation has arisen or exists whereby the security of India or any part thereof has been threatened, whether by war, external aggression, or armed rebellion, he may make the proclamation of national emergency. That means the President of India is satisfied that there is a grave of the situation that whereby the security of India is under threat. देशर सुरक्षाटा विपत्ति रे पड़ी. That means whereby the security of India or any part of the territory of India thereof has been threatened, whether by war. If any country they declares war against India, and it could be filled by the President of India, or any external aggression, that means बाह्य शत्रु आक्रमण, जदि कौन सी बाह्य शत्रु आक्रमण करिसेंती, then and there is any armed rebellion, सशस्त्र विद्रोह, then he may make the proclamation of the national emergency. So what happened, that is this article 352 of the Constitution of India, this is one of the special provision of the Constitution of India which empowers the presidents with national emergency, and whenever he will feels that there is any external aggression or war or that is your armed rebellion, then he may proclaim the state of a national emergency. And the actual occurrence of the war or armed rebellion is not necessary to justify the declaration of the emergency, but this, that is your war armed rebellion, the incorporated in the Constitution of India, that is your article 352 of the Constitution of India under 44th Constitutional Amendment Act 1978, and made the significant changes in the declaration of the emergency, that is national emergency, in order to distinguish from the other category of emergency. So this is all about the national emergency, but now we shall discuss about some of the effects of the national emergency. What are the effects of the national emergency? While national emergency is in operation, the Union Parliament's jurisdictions to the legislative enactment extended to the state lists. That means all the powers of the state governments were suspended, and the parliament or the legislative power of the parliament extended to the state list. This is one of the most important effects of the 352 of the Constitution of India. Second important effect is that the central government can give direction in the executive matters of the states. That means states do not perform any type of activity without the direction given by the central government. Then constitutional division of sources of revenue between central and state may be modified by the president. Constitutional division, that means, as you know, India is a federal state, and federal nature of the state, that there are some provisions that are included in the that is your union government, then there are some provisions there included in the state government, on the basis of which the state government has the power to enumerate rules and regulations. On the basis of that the provision of the union government has the power to make necessary rules and regulations. But while national emergency is in operations, all the powers are transferred to the central government for the formulations of different rules and regulations, and in the matters of anything, the state governments will directed by the central government. Then is your effects of next effect is the fundamental right or the right to freedom. Article 19 is ceased to operate temporarily. While national emergency is in operation, the fundamental rights of the people, they are ceased to operate temporarily, which I have already stated you. We have already discussed Article 19 of the Constitution of India. 14.2, that is right to, that is fundamental rights, right to freedom. 19 to 22, that is suspended. And next important feature is that is effected is that effect of the national emergency is that the fundamental right or right to constitutional remedy, Article 32, may be suspended by the presidential order. That means while there is the declaration of national emergency, the Article 32 of the Constitution of India, that is right to constitutional remedy, or which may issue writs by the Supreme Court of India on the basis of mandamus, certiorari, quo, these writs are to be suspended by the presidential order. These are some of the effects while national emergency is in operations. Then there is your state emergency or the president's rule, or that is your, you may say this is as the failure of the constitutional machinery also. That means here what happened under Article 356 of the Constitution, if the president received a report from the governor or otherwise satisfied that a situation is arising whereby a situation arising which amounts to the breakdown of the constitution or constitutional government in a state, or which amounts to the violation of the constitutional laws of the state, then he may proclaim the state of a state emergency. That means if the president on the received a report from the governor or otherwise he is satisfied that means either a written report is made by the governor of the state regarding the failure of the constitutional machinery, or the president himself satisfied that where there is the failure of the constitutional machinery of the state, then he may proclaim the state of a state emergency under Article 356 of the Constitution of India. And in this while there is the proclamation of the state emergency, what happened? All the function of the state government, excepting that of the High Court, are assumed by the president. This is one of the most important effect also, that while there is the state emergency is in operations, or one thing I must have to say here that the while there is the proclamation of the state emergency, the emergency, when the emergency is in operations, it ceases to effective after 2 months unless it has been approved by the parliament. 2 মাস ভিতরে সেটা 2 মাস পর্যন্ত সেটা লাগু ହେବ, otherwise it cannot be approved by the parliament, and within 2 months the parliament must approve the proclamation of the state emergency. Then it cannot be issued more than 6 months at a time. 6 ମାସରୁ ଅଧିକା ତାକୁ approve ଲାଗୁ କରାଯାଇ ପାରିବ ନାହିଁ. That means state emergency should not be extended more than 6 months at a time, but it can be extended with every 6 months up to a maximum period of 3 years. 2 মাস ମଧ୍ୟରେ ତାକୁ ପାର୍ଲାମେଣ୍ଟ approve କରିବା କଥା, ନହେଲେ it could be invalid. And second ହେଲା ଯେ ତା गोटे थरे 6 मास पर्यंत करि परिबे, एक्सटेंड करि परिबे, and in this way they will extend up to a maximum period of 3 years. So the extension is subject to the approval of the parliament. Time by time parliament taku approve korudobo. And while the state emergency is in operations, all the functions of the state government except that of the High Court are assumed by the president, and that is the reason where it is otherwise known as the president's rule. That is the reason where it is otherwise known as the president's rule. Second is the important effect is that all the powers of the state legislature are exercised by the union parliament. While the state emergency is in operation, then all the powers of the state legislature are exercised by the union parliament. The parliament has to make power to make different rules and regulations whenever there is the state emergency. That means the state machinery will be defunct. Then the parliament also delegates the power, may also delegate these powers to the president. All these powers would be delegated to the president. So the president exercise this power or the power of or the emergency power under Article 352 of the Constitution of India and proclaims emergency of a state or a situation of emergency in a state while the constitutional machinery will fail, or that may be termed otherwise known as president's rule in a state. So next is your financial emergency. What is financial emergency? Under Article 360 of the Constitution of India, the president promulgates financial emergency, or if the president of India is satisfied that whereby a situation has arisen whereby the financial stability or the credit of India or any part thereof is threatened, may proclaim the state of a financial emergency. That means if the president is satisfied that a situation is arising whereby the financial stability or credit of India, that means, as you know, all the things in a country or in a family, rather, you may say, finance is the most important thing which will determine the, that is your acts and deeds of the, if you take into account a family, or if you take into account the that is your state. Say for an example, nowadays when the pandemic is going on, what is the situation of the India? Now the financial situation of India is going on suffering very badly. The reason is that due to this pandemic situations. No doubt there is, I am giving you the example. That means if the president is satisfied that a situation is arising whereby the financial stability or credit of India or any part thereof is threatened, he may proclaim the state of a financial emergency. And while financial emergency is in operations, there are some of the, that is your effect. That is, the state government can be directed by the president to observe certain principle of economy in public expenditure. That means nowadays you see how the state government or the government of Odisha is curtailing different financial expenses. देखिबाकू पाउथबो जे बुझुछ ना नहीं, फाइनेंशियल इमरजेंसी समय कौन हुए ना विभिन्न पब्लिक एक्सपेंडिचर गुड़ा को काटी दिया जाए. Then second effect is that the salary of union and state government servants can be reduced. Nowadays what is going on in this pandemic also, the situation is very critical. That is the reason why till today, from long days, the dearness allowances of the different employees of the union government and the state government were not be enhanced on due time. This is due to the financial crisis. And this type of situation whenever arises, the president may have the power to proclaim the state of a national emergency. Then third important is that the money bill of the state legislature may be reserved for the presidential considerations. The money bill of the state legislature also reserved for the consideration of the president. That means, as you know, in a state government or in a state government is final authority with regard to the different legislation, with regard to the different financial matter. But while there is the proclamation of this, that is your financial emergency, the that is your state government or central government directs the state government in each and every situations. Then next point of our discussion is that is your prime minister, who is the real head of the state. Prime minister is the real head of the state, and or the real executive head of the state. The executive power vested in the hands of the prime minister with the council of ministers. No doubt, all the powers or all the executive powers under Article 53, it is the president who is the executive head of the state, but prime minister is the real head of the state who exercise all the executive power in the name of the president. And prime minister, and while the prime minister is appointed by the president, he can only, that means appointment to the president of, that is your prime minister, office of the prime minister, the president have no choice. Only he has to appoint or invite the leader of the majority party or a person who is in position to win confidence of majority members in the house. That means, say for an example, no party secure clear-cut majority in the floor of the house. At that time, what happened? It is the discretionary power of the president that he has to nominate that who has the power to establish confidence of majority of members in the floor of the house. That is the discretionary power of the president, who has his own choice to whom he will call for and to form the government. That is the reason where the 14 days government of the Vajpayee government collapsed after 14 days, because they have lost their confidence in the floor of the house. So in this way, what happened? The president has the power, or the prime minister is appointed by the president, and the choice to the prime minister is not much more. He is only to, that is, you invite the leader of the majority party to the form the government, or on the other hand, he feels that a person who is in a position, if there is no clear-cut majority in the floor of the house, if he feels that a person who is in positions to win the confidence of the majority of the members in the house, he may call him for to form the government. And this is regarding the prime minister. So now there is the point is the council of ministers and the cabinet. So the cabinet, that means, or the council of ministers and the cabinet, that means the cabinet, and these two terms, cabinet and the council of ministers, these are interchangeably used sometimes, but they are different. And the council of minister or the ministry consists of different categories of ministers. All the time that means at the time of independence, there was no such institution as a cabinet in India. But later on, the term cabinet was used, and the council of ministers, that means all the council of ministers are not the cabinet minister, but or the cabinet minister, they are the council of ministers. And in this way, what happened? The cabinet serves three major functions. That is, it is the body which determines the government policy for the presentation of the parliament. What happened? That is your cabinet performs three important functions. That is, it is the body which determines government policy. That means all the governmental policies are determined by that is your cabinet. Then it is the responsibility, or it is responsible for the implementing governmental policy. Cabinet is also responsible for the implementation of the governmental policy. Then next is that it carries out the inner departmental coordination and cooperation. Cabinet has the power determined, that is carries out interdepartmental coordination and cooperation, because there is various types of department, various types of, that is your department exist in the to smooth functioning of the country. That is the reason why the cabinet made the interdepartmental coordination among them. And the cabinet meets regularly as it is the decision making body. Cabinet meets regularly, and as all the that is your functions are to be performed by the members of the cabinet, they meets regularly. They functions also, there are also four standing committee which are permanent in nature. These are the defense committee, economic committee, administrative organization committee, parliamentary and legal affairs committee, ad hoc committee, constituted from time to time. In this way, this that is your cabinet forms different committee, and they perform their functions. Next point of our discussion is collective responsibility. What is collective responsibility? Collective responsibility means all the ministers are equally responsible for each act of the government. Say for an example, a government is composed of coalition. Last time you have the experience of, that is your united front government. That means united front government is that is your coalition government. and the members of the cabinet were from the different political party. But this confidence, that means they are collectively responsible for their own act, and doubts and disagreements are confined with the privacy of the cabinet room. No doubt they are from the different political party, they are from the different orientations, different of opinion among them. Still then what happened, they that is confined to the, that is your privacy, to the cabinet room, and they have to maintain a common minimum program. No doubt if they belong to a particular political party, then there is no problem at all, because they have their secrecy with the different decisions taken by the government. But if they are belong to the different political party, then what will happen? They make a common minimum program and become essential for the maintaining a solidarity of the ministry. Otherwise, the ministry will be collapsed. And this is the reason where they were collectively responsible to their each and every act. Then cabinet and the parliament. The cabinet and the parliament, that means the core parliamentary government is accountable to the prime minister and the cabinet to the parliament. That means cabinet is the inner body and the parliament is consist of the members of the, taking into consideration the member. All the members are the members of the parliament. So next we come to the point of, that is your sources of the prime minister of power and the influence. What happened? The power, different powers of the prime minister were there. That is power to, that is your the prime minister has the power to appoint his ministry. Then that means the formation of the ministry, the that is your distributions of the portfolio. Then he is the chairman of the cabinet committee. He also sole advisor to the president, and he also leader of the nation. Because as you know, India or the government, in case of the India, it is a prime ministerial form of government. Then he is the leader of the nation, because he is the real head of the state. In this way, he power were influence, or there are influential in nature, because he always to the central, because he has to formulate his ministry. Because I mean to say that while the formation of ministry is there, all the powers rest with the prime minister, because on the basis of his own sweet will he has to choose his ministry. केउ केउ लोक तांकर मिनिस्ट्री रे रहिबे न रहिबे, he will the final authority and he will choose the that is your ministry, and on the basis of that they will function. And he also has the power to change of the ministry, inclusion of the different minister. This is the different portfolio were to be distributed by the prime minister to the different important personality having the knowledge over the particular area. As well as he is also the chairman of the cabinet committee, he is the chief coordinator of all the policies, he is also the sole advisor to the president. That means president is only the nominal head of the state, and he always acts in accordance with the aid and advice given by the prime ministers or prime ministers recommendations. So prime ministers regarding the parliament as well as one of the most important power of the prime minister is dissolution of the Lok Sabha. That means we have already discussed the Lok Sabha will be dissolved before the completion of the term, and it is the recommendation of the prime minister who recommends the president to dissolve the Lok Sabha, and it is one of the special power of the prime ministers. Last point of our discussion, that is president and the prime minister. So whatever it may be, the prime minister heading the council of minister is the real executive head of the state, and president is the only nominal head of the state. He is the only constitutional head of the state. He is the only, that is your ceremonial head of the state. but in real sense of this term, all the power are to be exercised by the Prime Minister in the name of the President, headed that is your with the Council of Ministers. So whatever it may be, there are some differences also while dealing with the different bills. Say for an example, at the time of the President Rajendra Prasad, there will be deadlock conventions is going on. That the head of the state is always bound by the advice of the Prime Minister or the cabinet, but at that time they that is your that is your Rajendra Prasad was unhappy at the Nehru government and attempts to reform the Hindu personal law. In the time of also that is your Gyani Joel Singh, one of the incident took place. He has also not signed or reserved the bill of that is your postal bill, which has sent for the presidential assent, and there is a deadlock between the that is your Mr. Rajiv Gandhi and Prime Minister Rajiv Gandhi and the Gyani Joel Singh. This is one of the two examples which I will give you regarding the deadlock established between the President and the Prime Minister. That means sometimes they may disagree with the advice given by the Prime Ministers and reserve the bill for the presidential essence. So whatever it may be, at last we sum up all the powers of all the executive powers of the government of India rest with the that is your Prime Minister, and the Prime Minister will exercise all his executive powers in the name of the President with the Council of Ministers. Okay, this is all about your executive. As the time is short, बुझी होची ना नहीं?
Yes, sir.
बुझी हला तो. So this is all about today's discussions, and we shall discuss in our next class regarding the block 3. Thank you.
Thank you, sir.
Sir.